Okay. I am recording this lecture early for you. As you know, actually that Tuesday is my birthday. So I'm recording this lecture for you early for week 5. So you will be able to have it in advance because I will be off on Tuesday. So I'm going to provide details about the week 5, and then we'll discuss what goes from there. So I'm going to share my screen. And here it is. So let's look at the grade book for week 5. So your assignment is warrantless searches, DNA submission, a discussion, and then your live classroom phrase that I will give you today. Okay. So let's take a look at the calendar, and you can see where we are. As you can see, the 3rd, which is Tuesday, that you will be able to submit your discussion posts. And then you'll notice that we have another lecture Friday at 7:00 p.m. That will be week 6. And the reason we're doing that is because the course ends on the 10th. All right. So in addition to this lecture, you will also have me again Friday, but Friday will be at the regular time. Your reply post is due, of course, Saturday. Your written assignment is due Sunday, along with your live classroom phrase. And be aware that the course ends next Tuesday, the 10th. All assignments must be in. Any submitted after that without a proper incomplete requested. And you know you have to get that not from your dean, not from your advisor, but from me. All right. Let's take a look at the announcement for week 5. And so here we go. Criminal procedure we'll be talking about. And you're going to complete the activities which I'll talk about: purpose of law, foundations of criminal procedure, and steps in the criminal justice process. And then, of course, your lecture, of course, it says Tuesday, but I'm giving it to you now for this week. Your initial post is due Tuesday night. DNA submissions. Your reply post is due Saturday, the 7th. Finally, your written assignment, warrantless searches, is due Sunday, along with your key phrase. Be sure you follow the rubric as well as what I say on the lessons tab. So I make sure, and remember, finish strong. And you know my motto: adversity is the springboard to success. All right. So let's take a look at week 5, criminal procedure. Let's start out by looking at the assignment so you'll understand the parameters of the assignment. So you have 3 scenarios, not 1, not 2, but 3 scenarios. And it says that read each scenario and determine, based on the notes, comments, information from your research, whether you as an officer would be permitted to conduct a warrantless search. Be sure that for each of these scenarios that you provide citations to support your position, and I would recommend case law. If you cite a case, be sure to cite the official court case. Remember, it starts out with a number and US, and then it has another number, and then in parentheses it has the year, such as Miranda versus Arizona, and then it'll give the 3 numbers for the volume, and then US, and then it'll give the first page that it starts on, and then it'll have parentheses the year that it came out. I believe it was 66. So for each of these scenarios, remember you're going to do this APA double space, okay, in a Word document. Very, very, very important. All right. Now, the question that somebody will ask me is how many pages, and it doesn't specifically give a certain number of pages. I say that I stand corrected. I stand corrected. It says in a 2 to 3 page paper, explain the basis for justifying. And you know what I want to do? I want to edit this so you can see it clearer. Let's edit it so I can give you some space. Okay, so now let's save that way. You can see it now. So it tells you in a 2 to 3 page paper, explain the basis for justifying or not justifying each of the 3 warrantless searches. Give reasons why the officers should not be allowed to conduct a warrantless search or why the suspect's rights were violated. APA formatted. Make sure you provide citations in the body of each scenario and references at the end. Include a cover sheet. Again, double space, okay? And it's a Word document. Let's take a look at this rubric. Again, if you fail to provide citations, it'll go automatically over here because it's considered as unclear, okay? So you want to do each scenario that way, but you don't want, we want to be over here, okay? Let me get that out of there. So you're dealing with the commands of the commands. I'm reading what I just saw. Your clear and comprehensive justification for the search in each scenario. Explain why the rights were violated, offering reasons in support. Provide credible sources. Remember, if you don't provide credible sources, then you are going to end up over here. Warning you. For each section, each scenario, remember the length of the paper as well, okay? Make sure you read the entire thing. Okay. The discussion, DNA submissions, your initial post is due tomorrow night. Now it says participate by May 7th, but that's the reply post. All right. And so you're going to look at this fact pattern. And then you're going to use this PDF to help you. Okay. And you can click on this and download it and use that. Very clear. And then your live classroom recording, it will show here. When you see it next, it won't have this here. It'll have the link as well as we'll be emailing it to you. Okay. Then your live classroom lecture phrase. So we have 3 areas that we're going to cover. So let's start out with what is law? Why do we have law? What's the purpose of law? Purpose of law. Well, one of the first words that I always teach my students is a substitute for the word laws is rules, rules. And they guide us as to how we should operate orderly. And that um, if you break the law, then you're going to probably suffer some consequences. However, though, before it can be determined whether you broke the law, you have due process rights, such as a right to the charges, written documentation called an information or indictment. You have a right to discovery, the evidence that the prosecution has in their possession to substantiate the charges on the information or the indictment. And it should match up with the statutes or codes in the whether it's a federal court or state statute. And these laws will be provided before you do. You can't violate a law that has not been in existence. That is an unconstitutional issue. Okay. So no, laws, as it says, not only regulate the behavior that we have, but regulate the relationship between how government operate, gives you your rights, as used in the Constitution, the statutes, the codes, as well as the cases. Okay. And so the key thing is that one of the great things about our system is that before you can be deemed to be a criminal, you have to be found guilty beyond a reasonable doubt. Or you could plead guilty, one or the other. Okay. And it makes it clear that the system that we have sets up that law enforcement agencies are held accountable to satisfying your constitutional rights before you can be adjudicated of a crime or found guilty of a crime. So our criminal justice system consists of law enforcement and investigative, that's the police. That's generally who you have first contact with. Courts, that's where you adjudicate for pleas or trials. And if you're found guilty of a crime, you deal with corrections, which would be jail, probation, or prison. All right. And then you have parole after you are in prison for a while. And you have the appeal if you're found guilty in the appellate court. Most jurisdictions within 30 days, they allow you to file an appeal. But each state determines their own parameters for the length of time before an appeal. So you have to be on notice of what you violated. It says our democracy in this country says that laws must be applied uniformly and fairly to all citizens, and that no one is above the law. That's the due process clause of the Constitution and the equal protection clause of the Constitution. But there's a lot of issues that we debate, and there are some questions over the debates. As it says, police are tasked with enforcing the laws and arresting violators. The courts appoint what we call public defenders if you can't afford an attorney, and defend you if you're charged with a crime. So you have the prosecution on one side, which represent the state or the people, and then you have the defense attorneys on the other side. And as I already said, the U.S. Constitution and the Bill of Rights. So what are the Bill of Rights? The first 10 amendments of the Constitution. And be aware that originally as written, the U.S. Constitution Bill of Rights did not, I repeat, it did not apply to the states. It applied only to the federal government. But then came the 14th Amendment, which applied those very same rights in 1 to 10 to the state courts. So you're familiar with several of these. Fourth Amendment, unreasonable search and seizures, which allows warrants as a requirement before a search can take place unless it falls into one of the exceptions, which I will provide you in just a few minutes as we cover. And so the government, it just says, can seize or search without obtaining a warrant if they can provide proof sufficient for probable cause, making it reasonable. And these exceptions are enunciated by various cases. All right, so you need to be aware of what those cases are, and you will be able to get that information. I have some information that I actually had in a constitutional law class that I teach, and I will send those to you in an email after this lecture, so you'll have those to help you with the exceptions and list some cases. So we deal with first consent. Consent is probably one of the easiest. However, you need to make sure and understand that, number one, the party who gives consent is qualified to give the consent, that the consent is freely given, voluntarily, and it can be verbally or it can be written. And this is the conditions, some of the conditions. It says consent is valid if a third party, so a third party consent, not the person, but someone else, has equal authority over the business, and it can be concluded that the absent person assumed the risk of that the cohabitant or roommate might permit a search. All right. Now, it's not easy to establish that, but that is just one of the bases. Consent to search is not allowed if one cohabitant or roommate or business partner objects to consent, even if the other person gives consent. So it must be given to both people if they're present. Parents may consent to search a child's living area if the parents have routine access to the area and the child is not a tenant. In other words, they're not paying rent. So if they're paying rent, that's a whole different ball game. Landlords, because you become landlord, cannot give consent to search if a lease or rental agreement is valid, or if there is no lease. Okay, you can't give consent. Another is exigent circumstances. What that means is that if there is probable cause to believe that if it would create a problem to get a warrant, and that the evidence could be destroyed, lost, or the person could escape, or there could be harm to someone. And then in those instances, officers are allowed to enter a home. So for example, if you're chasing somebody and they run into a home or private residence, and there's a reasonable fear of escape, destruction of evidence, or injury, then in that case, the law of exigent circumstances applies, and you do not have to take the time to get a warrant. It would make no sense. Think about the common sense aspect of it. So what the court does is it considers whether or not it's exigent by asking these questions. Was the offense serious, or was it one of violence? Was the suspect armed? Was the probable cause strong enough to believe that that person actually committed the crime? Was there strong probable cause to believe that the person was in fact on those premises, like you saw them or they were in your eyesight? Did the police identify themselves and give the suspect a chance to surrender prior to entry? Was there an ongoing investigation or decision to arrest prior to the suspect fleeing into the premises? And finally, if the police are responding to a domestic violence call, entry may be made if a person's health, welfare, or safety is concerned. Okay. So those are exigent circumstances. Open view. Now, pay attention to open view, excuse me, and plain view. If an officer sees contraband from a public vantage, such as in a parked car, looking through a window, putting a parking ticket on and it sees a bomb inside the car, then you can go into the vehicle without the warrant. That's obvious common sense. Plain view operates very similarly. It says if an officer is conducting a lawful traffic stop with probable cause, or if they're in a home or business in which they entered for a lawful reason and they see the contraband, then they may seize the contraband, whether it's in the vehicle, on the table, or something along those lines. It has to be in plain view. All right. Pat down frisk. This is called the Terry stop, and it's based on Terry versus Ohio. And you should be well familiar with that, where the officers are allowed to, if they observe what they appear to see crime is what the justice said in the case, crime is afoot, which means that crime is inevitable taking place wherever that person is. And so what that officer can do is frisk that individual for weapons. And the purpose for that is the protection of the officer or others. The limited pat down is to outer clothing, in addition to the stop itself. So let's say, for example, if you're patting somebody down, their coat, they have a coat on, and then you feel a weapon under there. You can ask them to open it. If not, then you can actually check in that. And the purpose for that is for the belief that there could be some danger to the officer. But it may include, but is not limited to, prior knowledge that the individual carries a concealed weapon, suspicious activity, such as failure to comply with instructions, suspicious bulges, like what I was talking about, consistent with weapons, or finally, prior knowledge that the suspect is a member of a gang known to carry weapons. And then you can have a Terry stop. It's brief in a short period of time. Search incident to an arrest is another exception. An officer may incident to a lawful arrest. So let's say, for example, if a person is placed under arrest, they're in custody, they're not free to go, then the officers can search the person and the area within their immediate control, such as the immediate area in which the suspect was arrested, as such as a home or a vehicle. Custodial search. Custodial search. Officers can thoroughly search the persons of arrestees who are taken into custody. The search shall be conducted as soon as possible after the arrest and before transporting the vehicle. Evidence of any crime which is discovered in the course of that valid custodial search can be used to support subsequent charges if they're appropriate. Now, one of the things that you should be aware is vehicles have a special search because they are movable. When I supply that information to you, you will have that. Okay. So those are some of the exceptions. So what are the foundations of criminal justice. As you can see, I enjoy doing what he's doing, and I captured the attention of my jurors pretty well, winning about 90% of my cases. Crimes are broken as based on the statutes, as I said earlier, and an individual must have had the intent that was provided in the statute to identify, in fact, that if they take some kind of action or acts they participate in could be violation of the law, and punishment can come about. So in criminal procedure, the federal government, as well as all the local, state municipalities, have codes, and those codes specify the processes. The Illinois Criminal Code is the one that we have here, and it tells how the law is enforced, how trials will be conducted, as how evidence is gathered, and how you can what we call suppress evidence by filing motions to suppress when there's an apparent constitutional right that was violated in gathering that evidence, such as what we call the fruit of the poisonous tree. That's when evidence comes about from not obtaining a warrant, no probable cause, and there's no exception to it, to obtaining the warrant. Okay. So it's quite clear from the first 10 amendments, known as the Bill of Rights, that due process involves the guarantee against, as we said already, the Fourth Amendment, unreasonable search and seizure of property, self-incrimination. That's the Fifth Amendment, the right to have an attorney. That's the Sixth Amendment, and a right to excessive bail as well. And that as well is the Sixth Amendment, and then the speedy trial by a jury. Okay. So when a lot of people don't understand that when you have the sections, I'm going to, my correction, for bail, I thought I was wrong about that. Excessive bail is the Eighth Amendment. Excessive bail shall not be required, nor excessive fines. Yeah, so that's the Eighth Amendment. So I thought about that when I said that. I said, I don't think I said that right. So excessive, so going over that again, and interrogation and self-incrimination is the Fifth Amendment. Excessive bail is the Eighth Amendment. The right to a speedy trial and jury is the Sixth Amendment, and the right to cruel and unusual punishment is the Eighth Amendment as well. Okay. So we talked about this before, but the exclusionary rule, it means you can exclude evidence that if the Fourth Amendment is not applied properly. And it says that if the evidence is illegally obtained, it can be excluded from use at the trial, and to use it would be a mistrial and the person could go free. Speaking without an attorney present, the Fifth Amendment guarantees that, as you know about the due process rights and the rights of the Miranda warning. And so when a person, as I said before, and I say it time and time again, is in custody and not free to go, they're considered as under arrest, and the Miranda warnings must be given if you're going to ask questions. It says here that a good form to remember when the Miranda warning is arrest plus interrogation equals Miranda. So if you arrest somebody and you don't give Miranda, you're going to have that evidence excluded from trial on a properly filed motion to suppress. Okay. the Sixth Amendment right to counsel, which was presented in the leading case of Gideon versus Wainwright, the right to a counsel during a trial, and other cases. And it goes hand in hand with Miranda. So you don't have to speak to the police. I always used to tell my clients, don't say anything, because it means what it says. Anything you say can and will be used against you. All right. If you can't afford an attorney, then what we call a public defender, who is an attorney, very qualified attorney to represent you. So we talked about this a few minutes ago, that the rights are open to interpretation. And so the courts have done so, as Gideon versus Wainwright, as I was talking about, that the courts through the Sixth Amendment provide the right to counsel. It did not before Gideon state that the court was required to provide counsel. However, after Gideon, the courts are now required to provide effective counsel for individuals who cannot afford an attorney. Other elements of criminal procedure have what we call the rules of evidence, which govern the evidence that's admitted into trial against a defendant. And we have what we call the federal rules of evidence, which many states have implemented in their own state rules of evidence. And the purpose of that is not to allow information to come in a case to be used as evidence if it creates if it doesn't bear credibility. One of the ones that a lot of people know is the individual who gives secondary information and doesn't have direct knowledge of that. It's what we call hearsay, and it's not based on your direct knowledge. And so our system is designed to allow the judge or the jury, if it goes to trial. For example, the prosecutor represents the state, defense, or public defender, the defendant. Now, I remind you that 90% of the cases that are filed do not, I repeat, do not make it to trial. They are concluded by a plea, or what we call plea bargaining. Okay. So it is important that the defense and the prosecution do the best they can to provide the best possible evidence for their clients. The defense to defend the individual, and the prosecution to prosecute those individuals. Okay. There are some processes that we deal with technology, such as now we have in recent years DNA. DNA revolutionized criminal defense. When I was practicing, DNA had not come about, but it came about at the end. And actually, I liked DNA because it was stronger even than fingerprint, because what it would do is it would provide about a 99.99% determination about whether an individual did commit a crime, using the saliva and the liquids from the body can determine whether an individual is involved. Then the fingerprint analysis has gotten even better. Then we have cameras involved and other electronic things. But DNA is a very good tool in solving crimes as well as finding individuals. So let's conclude with what are the steps. And these are the basic steps that take place in a trial, in the criminal justice process. First is your arrest. If you're placed under arrest, then at this point you have pretrial activities, and the initial appearance brought before a judge at least 24 to 48 hours. 48 hours is the max. And given the formal charges as well as advisory rights, opportunity to have an attorney present, and finally the opportunity for bail, reasonable bail. Remember, the Constitution does not say you guaranteed bail, but reasonable bail. And depending on the seriousness, the defendant could be released pending their next court date. Now, you can be released on cash or either property pledged or either what we call a I bond, which is I for recognizance bond. And those are usually given to individuals in offenses where there's not a violent offense involved, and also where the individual does not represent a flight risk. Okay. The next step is a preliminary hearing or grand jury. Now, the prosecution likes to do the grand jury. And the reason why they like to do the grand jury is because the grand jury goes to a jury which determines whether or not there's sufficient information to file what we call an information and brings the defendant to trial. The preliminary hearing is what we prefer as defense attorneys, where what you have a chance to do is to prove to the judge, there's no jury present, whether or not there's sufficient evidence or probable cause to hold the case over for a complete full trial. If it's determined that it's not, then the case is dismissed. Once an indictment is returned or an information filed, then the accused can be formally arraigned. In the arraignment, it serves two purposes. It's just to inform the defendant of the charges and ask them to plead guilty or not guilty. That is it. That's it. If you saw the movie My Cousin Vinny, you remember Joe Pesci as the attorney representing the individuals, or the youths as they became famous, or youths is what they were trying to say. He was starting to explain his case, and the judge said, Mr. Gambini, that was his name, the attorney that Joe Pesci was playing, you either plead guilty or not guilty. If you plead guilty, then it goes right to disposition. But most cases don't result in that. The defense will say not guilty. Okay. And then after that, if the person pleads guilty, then oftentimes there's what we call a plea deal entered, where they begin to negotiate for a plea. A pre-sentence investigation is ordered, and so they can find out about the criminal history of the individual, and there'll be some agreement reached which the judge has to approve for voluntary plea. Okay, notice what it says. It says in here that plea deals are commonplace, and as many as 94%, well, 90 to 94% of the cases are resolved through pleas. Basically, a small percentage actually go to trial. And that works well because we don't have enough judges, courtrooms, prosecutors, and that to for persons. You'd have some lock and possibly some speedy trial issues. If the defendant pleads not guilty, then the initiation begins. And what happens is that there's discovery or disclosure filed to receive copies of whatever the evidence that the prosecution has. And so after going through that process, then if the individual decided to select a jury trial, then in that case, the jury selection begins with what we call voir dire examination, which is to seek the truth. in which questions are asked of potential jurors to determine whether they're fair and impartial. And at that time, defense attorneys, as well as prosecution, are given what we call peremptory challenges, or challenges for cause, maybe. So challenges occur if the defense attorney believes that the pool of jurors are not representative of the community. So, because remember, it should be a jury of the peers. And the challenges can occur even if the attorneys believe that the jury is not impartial using a peremptory challenge. However, you cannot use it to strike somebody because of their race. You don't have to give any reason, but if it's apparent that that's the reason, then you can't use it that way. So after the jury is selected, generally it's 12 and 2 alternates, opening statements begin. And the prosecution goes first because they have the burden of proving beyond a reasonable doubt the guilt of the defendant. And the opening statements are given just to give a summary of what they intend to prove. Now, it is not evidence, but it's more of a summary. Evidence consists of 3 types, what we call direct evidence, which is evidence to prove a fact that's required by the judge or the jury to draw an inference. So you see it. Circumstantial evidence is indirect, and you don't necessarily have to see it directly, but you draw conclusions based on it. So if a person produces a gun as evidence, then that's considered as direct evidence. And oftentimes circumstantial evidence, though, comes in when you don't have any physical evidence to provide. Or it might be a combination of physical evidence, which is direct, and circumstantial. Real evidence consists of material things like tire tracks. If you saw my cousin Vinny, you know about that. Notes, fingerprints, DNA, or things of that nature. And oftentimes when you get to this real evidence aspects of it, you bring in what we call experts to testify. And those experts can undergo what we call voir dire, not the same, but the reason for this voir dire for experts is to determine their qualifications to testify as experts in a trial. I won't go much deeper than that. Once the evidence has been submitted and examined, the attorneys are ready to give their closing arguments. So both sides have rested, and the rebuttal witnesses maybe have come, if there were any, by the prosecution. And so finally, the judge will allow the attorneys to give their closing arguments. And what they do in their closing arguments is summarize the evidence. Now, the ideal thing is that the opening statements and the closing should match. Or if there's something that benefits you that came out in trial, you will include that in the closing argument. And so what attorneys do, and this is what we did, is draw attention to inconsistencies in the evidence presented during the testimony. Defense attorneys present first, followed by the prosecution. And then the prosecution gets the last bite. Once that's completed, the judge will issue what we call jury instructions. And the judge will give those pattern jury instructions, which most jurisdictions have. Illinois has a book of pattern of jury instructions, which describe the elements of the crime that's been charged. And the judge will provide that information to the jury and they can take that into the jury room and use that to determine whether or not the person is guilty. The jury standard is beyond a reasonable doubt, and juries then begin to deliberate. In most criminal cases, the first thing they do is select a foreperson. But all jurors, I repeat, must reach a verdict. In other words, there must be a unanimous verdict of guilty in order to convict someone. If there is not a unanimous verdict, then we have what we call a hung jury. If a jury is hung, and my daughter, she did that with a criminal case some years ago, the state can then determine to try that person again with another jury. And so then if the sentence, if it results rather in the individual being found not guilty, the case ends. Person's free to go. But if they are found guilty by that jury, then in that case, sentencing is set and there's a sentencing hearing. And at the sentencing hearing, there's aggravating factors about where witnesses come in and testify for the prosecution, and mitigating circumstances are presented by the defense to reach a sentence. And as I will remind you, a PSI, what we call pre-sentence investigation, is conducted by the probation department and is utilized in terms of determining sentencing. And the sentence usually occurs at a date different than when the jury found the defendant guilty. And those are the steps when a case does go to trial. Okay? All right, so I am going to give you an opportunity to take and gain some points. Let me stop sharing. And you get your points by providing me with a key phrase or word. And in this case, I want to give you one that is pretty straightforward here. Criminal procedure. I don't think I used it before, but criminal procedure is what it is. So I want to say good night to you, good afternoon to you. I look forward to seeing you on Thursday for our week 6 lecture as we begin to conclude. If you have any questions about your assignments, feel free to reach out to me. I will not be responding on Tuesday because I'll be off dealing with the memorial service for my mother, which just happened to take place on May 3rd, which is my 72nd birthday. So you guys, I look forward to seeing you on Thursday for week 6, and stay safe.